The Portland Business Journal Thought Leadership Podcast, sponsored by Moss Adams, featuring top professionals and providing insight to keep you and your business informed. In this episode, we focus on South Dakota with Moss Adams tax expert Rob ONeill. Rob joining us from the Portland office. And Rob, it's interesting what's happening here with this tax case. South Dakota, the focus, because the United States Supreme Court has a big decision that could impact companies right here in Oregon and Southwest Washington, right?
Yeah, thank you, Brian. Yeah, most people won't think of South Dakota as the state that's going to be fighting, one of the biggest tax cases that we've seen since 1992, but they are, and they're adverse to a company called Wayfarer. And we know Wayfarer is a furniture store that we buy, fancy furniture online, but they're up against the Supreme Court trying to decide whether or not economic nexus is legal. And what economic nexus is a concept that's been developed that requires out-of-state companies with as little as $100,000 in annual sales in South Dakota, in this case, or as 200 in total transactions to begin to collect sales tax. And why this is interesting is it flies in the face, this law that South Dakota passed against Supreme Court precedent that was set in 1992.
It's interesting because, especially in Oregon, we don't deal with sales tax now unless you're doing business in other states. So this doesn't seem so bad. Why is this a big deal?
Well, I agree. On its surface, it doesn't seem like a big deal when most companies don't have a lot of sales tax to worry about in South Dakota, because South Dakota is a small market. But it is a big deal because if Wayfarer is unsuccessful at the Supreme Court, companies may need to start complying with similar laws in other states. And there's been a long precedent with not having to collect sales tax when you didn't have some sort of physical presence in the state, which is really what the case in 1992 required, is that in order for an out-of-state company to start to have to collect sales tax in a state that they're selling into, they had to have some sort of physical presence. And the most common that we might think of in day-to-day life is you're a traveling salesperson, you go into a state, you solicit an order from a customer there, and they make an order, and then you ship into the state from outside the state. Well, that was held in quill to be enough of a physical presence for a state like South Dakota to begin to impose sales tax on an out-of-state customer or company. Or another type of nexus that would be created is having a storefront in a state. Well, what's at issue here is Wayfarer doesn't have a store or salespeople in the state. All they have is economic activity. They have sales greater than $100,000. And that's what the Supreme Court's trying to decide, is whether that's enough of a connection to South Dakota in order for South Dakota to regulate and tax an out-of-state company like Wayfarer.
This is the Portland Business Journal Thought Leadership Podcast. I'm Brian Bushlack. We're joined in this episode by Rob ONeill, who's a state and local tax partner in the Portland office of Moss Adams. And, it's interesting how this has evolved because there have been, I guess, some changes since this case was decided, right?
Yeah, back, in the 90s, a lot of the commerce done across the U.S. was, done through handshakes and relationships, in person. And commerce has changed a lot since 1992 when the original case Quill versus North Dakota was decided, which set the physical presence requirement for Nexus. Now we have billions and billions of dollars of transactions that are done wholly on the internet. And states are arguing they're losing out, and arguably they are, on sales tax as a result of the way commerce has shifted to doing more business, via remote sales and sales done on the internet. Additionally, as a reaction to that, states have started to change their laws around sales tax nexus. And they've created a whole new set of laws that were intentionally done to circumvent the protections that Quill provided, the physical presence requirement. And what this has done for business is created a lot of uncertainty. And uncertainty for business is bad. And it makes compliance with these laws very costly. A couple of examples of new laws that have been created to circumvent Quill include things that are called affiliate nexus and click-through nexus, and another one called cookie nexus, which happens to be my favorite, which deals with a physical presence created through a cookie that's actually put on your computer if you're a resident of a state by an out-of-state company. And that cookie, that little intangible thing sits on your computer, was deemed to be enough of a physical presence for a state to impose a sales tax on an out-of-state customer. And most recently, economic nexus, which is really what's at issue in Wayfarer, is merely having enough sales into a state, enough of a reason for a state to be able to tax an out-of-state company.
So what happens if Wayfarer loses and South Dakota's economic nexus law is acceptable? I guess what happens if Wayfarer wins and South Dakota loses? There's a lot at stake here.
Yeah, people in the state tax community are really excited by this. Everyone's been focused on federal tax reform, and this has kind of flown under the radar. And a lot of people that are practicing in this area are excited because we're going to get some clarity around, what direction we're going to head. I think if Wayfarer loses and South Dakota were to prevail, it would mean that any company selling into South Dakota that has $100,000 in sales or more would now be deemed to have economic nexus and would be required to collect and remit sales tax to the state. That doesn't seem so bad as it relates to South Dakota, but the precedent set by this would really pave the way for other states to follow suit. They almost certainly will. I believe at least a dozen states have similar laws on their books. While some are enforcing them today, others pass them with the expectation that one of these cases would get picked for the Supreme Court and either affirmed or deemed legal. And as a result, if one is deemed legal, like in this case, Wayfarer v. South Dakota, with the strike of a gavel, this economic nexus concept would become legal, and sales tax collection, as we know it, would be forever changed.
Rob ONeill is a state and local tax partner at the Moss Adams office in Portland, joining us here on the Portland Business Journal Thought Leadership Podcast. And this is pretty interesting what's happening here, and kind of reset for our audience. You look at what could happen here, particularly for businesses in Oregon, and I guess the threshold is $100,000 in revenue in that state, so it won't impact a lot of mom and pops. But you look at the implications of this for businesses in Oregon doing business outside the state. This is huge, isn't it?
Yeah, we have hundreds and hundreds and hundreds of companies in this region, that are selling all over the country, and $100,000 does seem like a big number, but it's really not. For your middle market company, which is really what Oregon's made up of, there's lots of companies that will be affected by this, and especially Oregon companies, because they're not used to as much dealing with sales tax, and to with the strike of a gavel now have to start to comply, in all these states across the country. That's a pretty significant burden to place on commerce and Oregon businesses specifically.
Okay, Rob, I'm going to put you on the spot here. Who do you think's going to win this thing?
I wish I knew the answer to that, but I can't really predict who's going to win. Most of the people that I talk to and are in this state tax community, say it's too close to call. There were oral arguments, coincidentally, on the tax deadline of April 17th this year, and most people in the know say arguments for and against economic nexus were both pretty solid. And right now, I'd say it's probably a coin flip.
Wow. Well, I guess last question then would be for our business owners that are listening to this that could potentially be impacted. Is there anything they can be doing now to get ready for this?
It's something that, I think quite a bit about and consult with companies on quite a bit about. I think the first thing I would do is you got to go look at those skeletons in the closet. You got to understand what exposure you have today, because when these new laws are triggered and, in the instance, Wayfarer is unsuccessful at the Supreme Court, you're going to have to start complying with state law, new state laws and existing state laws, and selling your product to the state and now having to collect sales tax. And that's going to cause you to have to register for sales tax. and it could trigger some liability that, relates to prior years. And I think it's really good and responsible to go and look and understand what that exposure is. Prospectively, I would start to look at solutions for how to start complying with collecting sales tax. Whether sales tax is something that you're going to have to do, or you're going to have to start complying with use tax notice requirements, which is a separate issue we're not going to talk about today. But it's a similar burden that could be placed on your business if Wayfarer is unsuccessful at the Supreme Court.
Well, great insight. Rob ONeill, state and local tax partner in the Portland office of Moss Adams, providing perspective on this important tax topic. You're listening to the Portland Business Journal Thought Leadership Podcast, sponsored by Moss Adams. For more downloads, visit our podcast hub.